Also, under this acquired plan, the buyer assumes all potential liabilities associated with maintaining the plan. That includes issues that may occurred prior to the acquisition. But the prior fiduciaries do remain liable for implications of the fiduciary's actions taken prior to the removal as fiduciaries. They're responsible for a breach that occurred on their watch. But if that continues to be a breach once the plan moves to the buyer's plan, then the buyer's fiduciaries are responsible, whether they realize it or not. This may result in duplicative efforts if the buyer already maintains a plan that would be managing two plans. And also, it may create additional administrative issues in cases where the participants may transfer back and forth between the plans and/or companies and divisions. However, that works. If the decision is to freeze the acquired plan after close, a plan is considered frozen when no participant is benefiting from that plan. Benefiting from the defined contribution plan means if an allocation of either an employee contribution or a forfeiture is made to the account. So when is freezing the plan typical or perhaps optimal? It is if the acquisition has already closed without prior termination of the plan and no due diligence of the acquired plan was conducted, or when the plan is inadvertently acquired and the buyer wants new employees to participate in the buyer plan. Also, the buyer plan intends to restart or unfreeze the same plan at a later date if the buyer desires to merge it into their own plan, but only after it has the opportunity to conduct post-close due diligence review. Some additional considerations is that a formal action is required and that it is either a board resolution, committee resolution, or a plan amendment. Also, the plan must continue to satisfy ERISA and IRC code requirements, which means filing the 5500, maintains the plan document up to date, distribute any required distributions, monitor investments, determine reasonable list of expenses, continue making required minimum distributions. Anything that's required in maintaining the plan, managing the plan must continue. Also, the plan must continue to maintain qualified status. Full vesting is not required on part of the frozen plan as it would be with a terminated plan. So that's a big difference. And participants will continue to acquire their vesting service in this situation. Some other considerations include that this is considered semi-disruptive to the participants, as they may now have two plans, the frozen acquired plan and the new buyer plan. So it's a little disruptive for and confusing for participants potentially. Also, another consideration that the buyer acquires all potential risk and liability, all fiduciary liability comes across. The frozen plan may be merged into the buyer's plan, but a note of caution here that there are certain benefits that exist under the prior plan that are considered protected benefits, and they must be grandfathered into the new plan. So it's important that they go over with this new plan record keeper, the successor plan record keeper, to make sure that they can administer these protected benefits along with the new benefits that may cause duplicate plan provisions to be administered at the same time. So it's good to make sure that they're able to be taken care of by the buyer's plan's record keeper.